सर वॉइस आ नहीं रही है शायद।
आपकी वॉइस नहीं आ रही है। हाँ आपकी
म्यूट था, डिवाइस म्यूट था।
हाँ
Very good morning to all of you. Today we will be discussing very important another branch of intellectual property law, that is patent. In recent past, we all have realized, we all have experienced how this branch of law is important considering economic growth of the country. That's very important. It somehow I'm getting noise from someone's device. Kindly mute your device. So Malendra ji, could you please mute your device?
I'm doing that.
Malendra ji, could you please mute your device?
Yes sir.
Could you please mute your device? Mute. Yes, fine.
Okay sir.
Yes, fine. So another branch of IP, and it's a form of industrial property, and whenever we talk about this patent, it has to do with innovation. I told you that whenever we talk about intellectual property law, intellectual property rights, there are three things we need to protect by different mechanisms. First one is creativity, second one is innovation, and third one is business. We protect business as well. I can give you example of trademark law. I can give you example of geographical indication, designs. We have this kind of IP, and with the help of these IPs, we protect business as well. Even we protect the interest of consumers. But our today's discussion will be on one branch, that is IP, and it's part of industrial property. So this industrial property, and even I told you that there are two broad categorization of intellectual property law. One is copyright, another is industrial property. And this industrial property first time got recognized by international community, that Paris Convention 1884, long back, 1883, 1884. So this particular branch of law, patent, and it gives exclusive right to inventors. So we all know how research and development, scientific activities, scientific research, emergence of evolution of new technologies, industrial progress, how they are important to any nation, to any society, to any economy. And the very purpose, the very aim, the very objective behind protection of this invention, granting this patent, is definitely to motivate those scientists, those innovators. So, how we motivate them? By granting exclusivity, exclusive privilege. We grant exclusive privilege to sell, if it's any method, the selling of that method, the product, and using of that product, using of that particular what we call this method, but we grant it for a limited period. That's very important. We always make a balance. It's all about making a balance. Society's interest, public interest on one hand, individual's interest on the other hand. So we grant it for a limited duration. but we grant exclusivity. So many people are of the view that when we grant this exclusivity, somehow it leads to monopoly. So many people term this patent as monopolistic right. They say it leads to monopoly. It encourages monopoly in the market. But purpose here is not to promote monopoly, not to encourage monopoly. Purpose here is to motivate that innovator. Purpose here is to reward that motivator. And that's why we grant this patent. The nation grants this patent. Patent is a grant. It's not a matter of right. If somebody is claiming that I have invented this thing and I should be given this patent or I deserve this patent, so it's not a matter of right that cannot be enforced. Patent is a grant that comes from the state and it is regulated by law. Even though you have made any invention, even though it fulfills all the criterions, a state is not bound to give you patent. It's a grant. Many exceptional circumstances are there in which this exclusivity will not be there. You will not be enjoying this patent all alone because it's about exclusivity to use and produce. Whatever invention you have made, who can use it, who can produce it. Produce it means manufacture it. Who can sell it using manufacturing, selling. Exclusive right of that patent holder. But there are many circumstances in which this using, manufacturing, selling is given to someone else. That depends on the state. That's why it's a grant. And you all know the meaning, the difference between right and the grant. It's a grant that comes from the sovereign, comes from the state. And more interestingly, this grant is for limited time duration. That's the beauty. Limited time duration. It varies from one country to another, but the minimum protection that is afforded by the TRIPS agreement, and we also, being part of that TRIPS agreement, we have amended our law so extensively after that 1995. And in India, we allow this patent for a period of 20 years. After 20 years, it falls in the public domain. Anybody can make use, anybody can sell, anybody can manufacture without asking that innovator, that patent holder, because term has been elapsed. So after elapsing of that duration of 20 years, it goes to public domain. So you can easily understand how useful, how beneficial it would be to the nation, to the society. And that's why this grant is given. We all want a comfortable life, and for leading a comfortable life, our life is surrounded with many technologies. We take help of technology. Every government wants to have more and more scientific researches, more and more technology, more and more new novel methods, industrial progress. Because it's when I give example of India, it's welfare state. You all know that in welfare state, the responsibility of the state to protect the interest of citizen by different means. So when this question of scientific research, research and development, technology. So broadly, we say science and technology. So in science and technology, you all might have experienced, might have seen that how our government promotes, how our government motivates all such activities. And during pandemic, we have seen much because we have started innovating very many things. We started innovating many things. We invented even that vaccine, COVID-19 vaccine. So whenever this invention, research and development, scientific activities, what is important, I have already told you, motivation and reward. So by giving reward, this scientist can be motivated. So that's the purpose, and this patent is granted, but it is always regulated by law, and this is for a fixed period. So even if it is a monopoly, it is for a fixed period. It is not for ever. Thereafter, it passes into the public domain. As far as the historical background of this patent system in our country is concerned, so definitely it was brought by the Britishers and Indian Patents and Designs Act, the first Indian Patents and Designs Act that was actually brought into existence, brought into the force by Britishers 1911. But after getting independence, we realized that we should have our own patent act. So we enacted this patent act in 1970, and so many amendments took place after enactment of this act. But particularly when we became signatory to WTO, so being a member to that signatory member to that TRIPS agreement, so we had to make extensive changes in our patent system. So we amended our laws so extensively, particularly in the year 2005. 2005. And I can highlight one very important amendment that was made in the year 2005, because many people have this misconception that before 2005 in India, we had only a process patent, we didn't have product patent. We introduced product patent for the first time. This misconception in the mind of large number of people, but this is not correct. We had both kind of patents, because patents are of two kinds. Patents are for two things. First, invention of process, invention of product. So we grant patent for process also, we grant patent for this product as well. But when we omitted that section 5, resulting into allowing product patent in important areas, important sectors that were actually not allowed prior to 2005. We had Section 5. And as per Section 5, because India was a developing country and it had its own requirements. So, considering its own requirements, India availed the full duration of the transition period. WTO actually gave, because it was all like a negotiation between among countries, and all groups, they had their own interest. The developing countries, they had their own interest. Developed countries, they had their own interest. Least developed countries, LDCs, they had their own interest. So they all wanted to protect their interest, and this Uruguay round of discussion took place for many years, more than 20 years. And finally, they reached to a conclusion. And when they reached to a conclusion, definitely when they accommodated everyone's interest. So, TRIPS agreement that WTO facilitated all developing and LDCs to avail a transition period, because their concern was that we are not advanced and we don't have technology, we don't have much scientific inventions in our country, and we are not in a position to implement the minimum standards required by the TRIPS agreement in that 1995. So this is not the right time. We are not in a position to implement it. So we want some more time. So that more time which was given to developing countries, which was given to LDCs, that's known as transition period. Transition period. And India availed its transition periods, because for developing countries it was 10 years. For LDCs it was 16 years. So India availed its transition period for full duration of 10 years. So Act that TRIPS agreement came into being 1995, and we continued with our earlier law till 2005. After availing that 10 years of transition period, it was mandatory to make changes. and to make it at par with the TRIPS agreement. And we did it. And that's why we had to omit Section 5. And Section 5 was to prevent product patent, that was to restrict product patent in certain important sectors. Because once a product patent is given, others will be denied to make that product without the consent of patent holder. Though, when it's a matter of only process patent, only process is confined, only process is monopolized. If somebody wants to make the same product by adopting a different process, that's possible. There is no hurdle, there is no problem, there is no legal issue. If there is only process patent, the monopoly is given with regard to that process. Exclusivity is given with regard to that process. So if anybody else wants to make the product by adopting a different process, so he can make it. There is no bar. So that kind of law we had in the form of Section 5, that was preventing product patent in certain sectors, considering the requirement of the nation. As I have already told you, India was a developing country. So you all know, for any developing country, what sectors are very, very important, the core sectors, where they don't want to compromise. First is definitely agriculture. When it's a matter of agriculture, another thing becomes very important, that is chemical. Because all fertilizers, all preservation of seeds and all that, you all know how useful chemicals are, chemical sector. Pharmaceutical, pharma sector. So food. So this agriculture includes food, chemical, everything. Then what I said, this pharmaceutical drug. So these were the areas in which product patent was not allowed. And when we amended our law in the year 2005, definitely we started allowing product patent even in these areas, because we had already availed our transition period and we were bound to make changes in our law to make it at par with the WTO requirements, the TRIPS requirements, and we allowed even product patent in all certain areas. But before that, some kind of even kind of system we had, because if somebody wants to file a patent of their product in all such areas, so during those 10 years, how it would be possible? How can we deny the invention which is made by someone with regard to a product? So for that, we actually adopted a different kind of system, and we faced a lot of difficulties because of that system. That was a kind of havoc on our legal system, and that was a case of EMRs, exclusive marketing rights. So the exclusive marketing rights provisions were there before 2005. So when we omitted Section 5 and we somehow repealed the provisions relating to EMRs, exclusive marketing right. And at the same time, to make a balance, that you all know, to make a balance between public interest and the individual's interest, we have different mechanisms like time duration, like compulsory licensing. So the provisions for enabling the grant of compulsory licensing also got introduced. So at the same time, we amended the provisions relating to oppositions, the pre-grant opposition, the post-grant opposition, and some people they question certain issues. I can give you example that, and as I have highlighted this important amendment that was made in the year 2005. So you might have heard about the patenting of our very important traditional knowledges, very important our uh, information, the geographical indication. So by someone in a foreign country, and people think that how it was possible, why that government, the US government, why that government allowed that grant of the patent. So people think that they are working against the interest of our country, and they are intending to grab our culture. They are intending to grab our knowledge, our ancient knowledge, our traditional knowledge, etc. So many allegations they make. But being a student of law, we should look at the law. We should look at the provisions. Why America granted a patent for neem? Why America granted patent for turmeric? Why it happened? So the answer lies in this fact that there is a difference in our legal systems. Though we maintain the minimum standards prescribed with the TRIPS agreement, so somehow it brings a kind of uniformity, though not absolute uniformity, but a kind of uniformity. So minimum standards are there prescribed by the TRIPS agreement. India, being signatory, being member, follows it. Many other countries, they also follow it. But question here is, why America granted it? So when you look at the legal aspect, when you look at the legal system, the patent system of both the countries, then you would appreciate why America granted a patent to all such knowledges of India to someone in USA. And subsequently it got revoked. We succeeded. When we objected, we succeeded as well. That's the fact. We fought the case, true, but we succeeded. Why we succeeded? Just because of difference in the system, difference in the legal system. In India, we actually invite oppositions when someone files a patent application. If someone claims invention and wants patent, we invite opposition. We invite opposition. Opposition from the member of the public. If this knowledge is part of the existing knowledge, because claiming invention is what? A knowledge, sharing of the knowledge is to make full disclosure. It's all about quid pro quo, something for something. He is giving a valuable information that is not with us. Inventor means what? He is having a knowledge with regard to something, and that knowledge is exclusive knowledge, and that knowledge is not with us. If that knowledge is not with us, it's novel. Its novelty is there. Novelty is the criterion. Novel. It's new. And that's why in reward, this exclusivity is given to that inventor. So if he gives us a valuable knowledge that is not with us, so what is difficulty in giving something in return? That is exclusivity. भैया आपने बहुत अच्छा ज्ञान दिया हमको, बहुत अच्छा नॉलेज दिया है, that will be very useful for the purposes of nation, for the purposes of society. Better you enjoy it for 20 years, and subsequent to it, it will fall in the public domain. It will be part of everyone's knowledge. Anybody can make use, anybody can sell, anybody can manufacture without asking you. Quid pro quo, something for something. So in India, we actually invite the opposition from public at two stages. Pre-grant, meaning thereby, before granting of the patent, we invite opposition. Examination will take place, we invite opposition, and then only the final decision will be taken by the authority, that is Controller General of Patent Designs and Trademark. And once it is granted, thereafter also opportunity is with the public. If they find this knowledge is not novel, they find this knowledge is not useful, because usefulness is also the criterion. That's why there is a criterion, industrial applicability. Industrial applicability. Not every invention is patentable. Which invention is patentable? The invention having industrial applicability. If the invention has no industrial applicability, no question of granting of the patent. So even where the patent is granted, subsequently, if anybody wants to make opposition, he is given the opportunity by our law. So we have a filing opportunity to raise opposition at two stages: pre-grant, post-grant. But in USA, in their patent system, they have this opportunity once. Post-grant, they don't have any opportunity at pre-grant. So there is no provision for pre-grant opposition. So when there is no provision for pre-grant opposition, if anybody makes a claim in before the US patent authority, if anybody wants to patent, so they don't have any problem in granting of the patent, satisfying the all requirements, and without inviting the opposition, they can grant the patent. If anybody has opposition, they can raise it after grant of that patent, because they have a provision for inviting oppositions, but not twice, only once. When? Post grant. पोस्ट ग्रांट पहले दे दिया जाएगा, फिर ऑपोजिशन इनवाइट किया जाएगा. डू यू हैव एनी ऑब्जेक्शन? Whether anyone have any objection? If you have, raise it. If we find it suitable as per our law, definitely this patent which is already granted can be revoked. There is no problem in it. But they invite opposition post grant. Post grant. And that's why this all controversy took place, and this patent was granted to all your traditional knowledges like neem, turmeric, basmati, the issue of basmati. It all happened. But as far as that's this all I have shared to apprise you the importance of this system, this patent system. But you need to understand the basics, the fundamentals. You need to understand the basics, because unless until you understand what does it mean, and what is the meaning of this particular term, what is the meaning of this particular concept, you won't appreciate the typical issues or the other important issues. That's why whenever we talk about this patent, as I have already highlighted, it's all about quid pro quo, something for something. But as far as this first something is concerned, that comes from that innovator, that comes from that scientist, the person who is working in the field of science and technology. So definitely, what actually is given to him, or what is the reward, what is the motivation, and what is the basics of your legal system. So you need to have a clear understanding of it. But many times you get a confusion as well. If you look at the law, we have Patents Act 1970, and your task is to know the meaning of patent. So if you want to know the meaning of patent, where you look? You look at the definition clause. When you look at the definition clause, it creates a lot of confusion. If you look at the definition of patent all alone, only that definition prescribed by the law is provided to you. You'll be confused. You won't be getting anything. If you want to know the exact meaning of this patent, you need to create a chain. Unless until you create that chain of getting the meaning, chain to get the meaning, this thing is defined or not clear. This particular term is used. Now you need to understand that particular term. If you go to understand that particular term, another term comes into the picture, and so on. It makes a chain. And if you look at them together, then you will have the broader picture, then you will have the proper meaning of this system. Why I said so? I said so because the very definition of this patent provided by your Act 1970 simply says patent means a patent. Patent means a patent for any invention granted under this Act. Simple. Patent means a patent for any invention granted under this Act. Only this much is provided. When you look at this definition, definitely this word invention is prominent. Then what does it mean? What is this? What's the meaning of this term invention? Now you are to find out the meaning of this invention. What does it mean? So invention means a new product. Invention means a new process. Invention means a new product. Invention means a new process. But which process? Which product? So the process or product involving an inventive step. The product or process involving an inventive step. Now you may ask, then what is the inventive step? Again, you have to look at the definition provided for inventive step. So inventive step is a feature of the invention. So whatever invention is claimed, because patent means a patent for any invention granted under this act. So one thing is clear, that patent is granted for invention. This thing is clear. Patent is granted for invention. So we can say that patent cannot be granted for discoveries. It says, impliedly it says that patent cannot be granted for discoveries. Patent can be granted only for inventions, not for discoveries. So what is invention? So invention is a product or the process involving inventive step. An inventive step is the feature of that invention. So what kind of feature it is? It involves technical advance. Technical advance. Whenever we use the term advance, this is comparative word, advance. Always it requires a comparison. Advance. You say, I am very advanced. So advance from whom? Without comparison, this term cannot be used. So you are bound to compare. Whenever you use the term advance, you are bound to compare. Without comparison, this term advance cannot be used. So technical advance as compared to the existing knowledge. So invention that involves technical advance. So this is the invention, and this invention has a feature. And what is that feature? Inventive step. And what is this inventive step? It involves technical advance as compared to the existing knowledge. Existing knowledge. If you remember, I said you in the beginning that this inventor has given information that is not with us. That is not with us. What does it mean? Existing knowledge, it's not part of existing knowledge. It's not part of existing art, that state of art. It's not part of existing knowledge. That's why we say this feature involves technical advance. How you reach to this conclusion that we don't have? First, you need to look at the claim, and then you need to look at the existing knowledge. You compare, and then you find that no, it's not part of existing knowledge. Definitely, this person has given something new, novel. It's novel to us. Novel to whom? Those who are in science. And if any information, even in science, there are so many branches: physics, chemistry, bio. So the people of chemistry, everything which is coming from that physics, that will be novel to them. For people of physics, anything which is coming from chemistry or anything coming from bio will be novel to them, or that will be uh, somehow novel to them. That's why we need to adopt that test, that the test of non-obviousness. This is non-obvious. So non-obvious to whom? Non-obvious to everyone. If we require non-obviousness to everyone, so definitely no invention will be patented. because whatever scientific activities take place, being a student of law, everything is non-obvious to me. So that non-obvious in whose perspective? Whether in perspective of everyone, all? No. Non-obviousness in the perspective of all those who are in that area. Who are in that area. Meaning thereby, if any invention takes place in physics, so all those who are in research activities in the physics, if this invention is non-obvious, if this knowledge is non-obvious to them, non-obvious to them, and you all know meaning of non-obvious, because we often use this term, obvious hai, obvious hai, because you have this information, you have this idea, you have this knowledge, that's why you react like this. Obvious hai, ye hoga to ye hoga hi. 2 + 2 = 4, obvious hai. 2 में 2 जोड़ेंगे तो 4 ही होगा. Everybody knows it. What is your contribution? आपने क्या बता दिया यहाँ पे? Are you getting it? So non-obviousness in whose perspective? Non-obviousness in the perspective of all those who are in that art. Who are in that art. So a feature of an invention that involves technical advance as compared to the existing knowledge. One more thing is very important, that is economic significance. Sometimes we don't want to compare with the existing knowledge. Sometimes if it is very, very significant economically, then why not to reward? Why not to reward? Just a minute, give me just 2 minutes. I take you 2 minutes, then I'll resume. Okay, just 2 minutes. Yes. Am I audible?
Yes,
Yes,
sir.
sir.
Uh-huh. So I was telling you that it's all about this invention, and this invention means a new product, a new process involving inventive step. An inventive step is a feature, and this feature actually involves this technical advance as compared to the existing knowledge, or having economic significance, or sometimes both. Sometimes both. And then it makes all those who are skilled in that art non-obvious. It makes this invention non-obvious. Non-obvious to whom? To all those who are skilled in that art, not to everyone. Because if you require it to everyone, non-obvious to everyone, then no invention will be there, no invention will be patented, and we will be deprived of getting advantage of many technologies. That's why this non-obviousness requirement is there, but non-obvious to whom? Non-obvious to persons skilled in that art. As far as this feature inventive step is concerned, this invention of that is a product or that is a process is concerned, we require one more thing, and that is capable of industrial applicability. If it is capable of industrial applicability, then only it is patentable. Otherwise, it is not patentable. So if you remember what I told you, usefulness. If this invention is not useful, then why to reward? Why to grant him exclusivity? Why to allow him to have monopoly? No reason. There is no question. And that's why we rely on usefulness. So this invention must be capable of industrial applicability, that industrial application, the industrial application. That's the requirement. That's the requirement. So this utility part, this usefulness part, in the terms of industrial applicability. So without it, see, this in fact earlier this was not the requirement. If I give you example, as I remember, there was 1911 Act, it was added subsequently, that when we are giving this because it's very pertinent to note that when we are giving this exclusivity and when we are allowing a kind of monopoly that is given to someone, so you all know how serious this act would be, how serious. So for any kind of invention, if it is to be given, so definitely that won't serve the purpose. So why not to rely on this aspect? Because usefulness, if your invention is useful, definitely you should be rewarded, you should be motivated. You get the patent. You get the patent. Otherwise, it's not it's not required. So the usefulness of the invention is to be judged by the reference of the state of things when that patent application is filed. How useful this one is, because whatever is useful today, it may not be useful tomorrow, you all know. So usefulness when at the time of filing of that application, if it is found useful, utility is there, industrial application is there, no problem in granting that exclusivity to that invention. At the same time, before I discuss that specific issue of this stem cell, one thing which is very important that I want to tell you, that instead of having a positive provision, our Indian Patent Act that incorporates a negative provision. Why I'm saying so? Because what can be patented if you are to incorporate this kind of provision? What can be patented? So our Patent Act would be voluminous, very bulky. What can be patented? So it's a joke, but it is said that every invention that takes place under the sun is patentable. Every invention under sun is patentable. It's a joke because our law does not say that what is patentable. Because when we start making the list, it would be a huge list. It would be voluminous. And that's why instead of having this kind of provision, we incorporated a provision what cannot be patented, non-patentable invention. Make a list. Exceptions. What cannot be patented, non-patentable inventions. And we have section 3, we have section 4. So section 3 and section 4 of the Indian Patents Act 1970 that gives you the categories of inventions which are non-patentable. I can share some of them, very important. A frivolous invention cannot be patented. The frivolous invention means, you all know meaning of frivolous and all that. A frivolous invention means, if I give you example that suppose some kind of device is made and that device is to create some kind of thing that is not natural and all that, fake, you can say fake invention. Frivolous invention means the fake invention, it's fake. So definitely that's not going to be patented by virtue of the section 3 of the Indian Patents Act. Similarly, if I tell you about this another kind of invention which is not allowed to be patented. So what is contrary to your law, what is contrary to your morality, what is injurious to the public health. Uh, uh, Definitely, that's not going to be patented. And you all know that so many things are there, something against law. Suppose you have IPC, and IPC prohibits theft. And if I have invented a device, and that to facilitate, that to make easy commission of this offense of theft, so you all can understand it is contrary to your law. On one hand, your law restricts this offense of theft. On the other hand, you have made the invention that to facilitate this commission of the offense of the theft. So definitely it is against that law and all that. If something which is against the morality and all that. So if something which is injurious to the public health, so one invention is made, but that invention is to cause physical harm to someone. That invention is to cause death to someone. So you have invented a very new kind of poison, and by giving that poison, you can kill a human being, not to animal, human being. So, what is injurious to public health? What is injurious to that human being? So, definitely, that's not going to be patented. So, so many things are there, like mere discovery of scientific principles, formulation of the abstract theory. So, mere discovery of a new form of known substances. Novartis case, evergreening of the patent. So, you all might have heard about the Novartis AG versus Union of India. So that was on Section 3D, and it was released by, because Novartis was a very big pharmaceutical company, multinational company, and Novartis lost the case before the Supreme Court. Novartis lost the case before the Supreme Court, and subsequently they released that India violated the mandate or the minimum standards prescribed by the TRIPS agreement, because the India did not allow us to get the patent. So but Indian Supreme Court interpreted the provision very accordingly. But here, my purpose is to make you understand that evergreening, it somehow prevents evergreening of the patent. Because if you remember, I told you that term is fixed 20 years. 20 साल के बाद ये पब्लिक डोमेन में जाएगा. आपको अगर एक्सक्लूसिविटी चाहिए, if you want exclusivity, you want monopoly, you better enjoy it, you reap out the benefit for this 20 years. 20 साल आपको दे दिएगा. बट 18वें साल में आप सेम प्रोडक्ट के लिए किसी और नए उसके कंपोनेंट को लेकर आप आ गए. जैसे मेडिसिन में होता है, सॉल्ट्स होते हैं वो बेसिकली, और उन सॉल्ट्स के डिफरेंट फॉर्म्स होते हैं. तो आप एक नया फॉर्म उसका लेकर आ गए, और वही सॉल्ट है, सेम सॉल्ट, बट एक नया फॉर्म उसका आप लेकर आ गए 18वें साल में, और आप फिर से पेटेंट क्लेम कर दिए. तो अगला फिर 20 साल के लिए हो जाएगा. तो 18 आपने ऑलरेडी इधर ले लिया और 20 फिर मांग रहे हैं. तो 20 प्लस 18 38 हो गया. फिर 37वें साल में आप फिर आ गए एक नया फॉर्म लेकर, फिर आप पेटेंट मांग रहे हैं. अगेन इट वुड बी फॉर 20 years. So it will go on. There will be no end of patent to this kind of invention. Then what will be the benefit of the public? आप खुद सोचिए, फिर इसमें पब्लिक का बेनिफिट कहाँ से होगा? पब्लिक डोमेन में ये फिर कब जाएगा? जिस चीज को पब्लिक डोमेन में 20 साल में जाना था, आपने चालाकी से उसको एक्सटेंड करा लिया 37 years तक, आपने एक्सटेंड करा लिया सपोज करिए 55 years तक, 67 years तक. So this is against the interest of public. Why our Supreme Court should allow you to do so? And that's why the Supreme Court interpreted the provisions very cleverly, and Supreme Court said that whatever provision we have in our Section 3D, that is very much compatible with the minimum standards of the TRIPS agreement. It is not in violation of the minimum standards prescribed by the TRIPS agreement. And this evergreening definitely should not be allowed. It should not be allowed. Similarly, when you admixture the substances, merely admixture of the substances, resulting only in aggregation of the properties of the component. So definitely that can also be not patentable. So different kind of provisions we have with regard to non-patentable inventions, because what cannot be patented. So a mere arrangement or rearrangement of the known devices. Mobile is the best example. So in this mobile, different technologies are there, but as far as the whole mobile is concerned, it's combination of many known devices. I gave you this example in previous lecture also, that in one device you have calendar, In this device, you have a torch. In this device, you have a clock. In this device, you have a GPS. In this device, you have a camera. So camera was already known before invention of this mobile. This GPS was already known. This torch was already there. This watch was already there. This calendar was already there. So mere arrangement और रीअरेंजमेंट ऑफ नॉन डिवाइसेस, आप सबको एक साथ, जैसे मान लीजिए गन है और गन में आपने एक साइलेंसर लगा दिया, तो साइलेंसर अलग से एक ऑलरेडी एक डिवाइस है और ये गन तो ऑलरेडी पहले से है। आपने क्या किया कि गन में एक साइलेंसर लगाया, अब ये एक नए तरह का डिवाइस बन गया, एंड नाउ यू आर क्लेमिंग पेटेंट। सो इट्स मियर अरेंजमेंट ऑफ टू नॉन डिवाइसेस। मान लीजिए एक गन है और आपको रात में शूट करना है और रात में आप देख नहीं पाते हैं, तो आपने उसमें एक नाइट विजन कैमरा लगा दिया, नाइट विजन कैमरा लगा दिया, उस गन के ऊपर फिट कर दिया, अब ये एक अलग तरह का गन हो गया। नाउ यू आर क्लेमिंग पेटेंट फॉर दिस न्यू काइंड ऑफ थिंग, यू से दिस इज इन्वेंशन, बट दिस इज नॉट इन्वेंशन which can be patented because it's mere arrangement. So where there is mere arrangement or rearrangement of the known devices, definitely that cannot be patented. Similarly, method of agriculture, the horticulture, any process for medicinal or surgical or curative or diagnostic therapeutic or method of the treatment of human being, any process for a similar treatment of the animal. So these are the things, they cannot be patented, considering the betterment of the humankind, considering the betterment of the life on this earth. Similarly, copyrighted materials are non-patentable, traditional knowledge is non-patentable. So all such categories are there in that section 3. And if you look at that section 4, so that is about atomic energy. And we have already one legislation, that is 1962 Act and Atomic Energy Act. And whatever falls in that Atomic Energy Act, definitely that is not patentable. That is not patentable because here it's a matter of national interest and all that. Atomic energy, everybody is not allowed to do research in the atomic energy. Only recognized agencies are allowed to do research in the atomic energy, because very serious consequences are there in case of any fault, in case of any breach dealing with atomic energy, you all know. So nowadays अभी जो रसिया यूक्रेन का वॉर हो रहा था, आप सबने देखा होगा कि जो वहाँ पे जो न्यूक्लियर प्लांट्स हैं उनको, उन पर कब्जे को लेकर जब आग लग गई वहाँ पे, तो क्या थ्रेट क्रिएट हुआ पूरे वर्ल्ड पर, बिकॉज रेडिएशन इज वेरी डेंजरस, यू ऑल नो, and it causes harm not only to present generation, it causes harm even to future generations. In Hiroshima, Nagasaki, we all have witnessed it. So it happens. So whenever we talk about this patent system that we have, so overall what we do, I can very precisely, because we have limited time, very precisely I can tell you that what kind of procedure actually we adopt with regard to this grant of patent and all that. So first of all, filing of application. When you file the application, you file this application with complete specification. But if your complete specification is not ready, our system allows you to file this patent application with provisional specification. Okay, so when this specification is filed, then a publication will take place. It will be publicized that this person has claimed this kind of invention and he wants patent. And after that publication, examination, there will be a request for examination. And in that examination, the different levels are there. That first examination report will be submitted, then reply to that first examination report will be submitted, and then re-examination will be there, re-examination and issue of any further objection, and then all objections will be compiled, and then only a final order will take place. So when it's a matter of inviting opposition and all that, so pre-grant opposition is there. If any opposition is filed, then hearing will be there, and after that hearing, the opposition, either that opposition will be allowed or that opposition will be rejected, and that opposition is actually not filed, or whatever that duration is given, that is 12 months and all that, then it would be abandoned. And if that objection is already replied, and controller general of patents and patent trademarks and designs is uh, uh, taking a decision, so after hearing the parties definitely and all that, so he may refuse or he may grant the patent. So even after grant of the patent, one stage is there, that is post grant opposition. And if that person who has raised this opposition, that post grant opposition succeeds in his claim, so patent can also be revoked. So we have this kind of a patent system. We have this kind of patent system. But as far as this particular issue, I'm taking the particular issue of that stem cells. So whether these stem cells can be patented or not. So what kind of policy we have, what kind of law we have. So definitely all criterions I have highlighted, what criterions are there, like inventive state, and that non-obviousness, that novelty, industrial applicability, that you all know, I have already told you. But as far as this stem cells are concerned, so definitely stem cells are very useful. You all know nowadays we are relying on stem cells for treating so many diseases, for the treatment of so many diseases. So stem cells, in fact, they offer hope as a promising treatment options for various diseases, and they are in fact the future of medicine, stem cells. So embryonic stem cells, and they have been at the heart of many debates nowadays at global level, globally. And in view of this embryonic destruction and manipulation that their generation may require, so definitely it's a matter of debate, and this debate is taking place at global level. And in India, as far as granting of patent to this stem cell is concerned, so the basic system I have already highlighted that. But one issue that we always take into consideration, and I have already told you, that is public order and morality. So over the years, our Indian Patent Office, and the very perspective of this patent office, the Indian Patent Office was what, that issue of patentability of any invention involving this embryonic stem cells, that appears to have changed. And this change in stance, in appearance, and that is somehow apparent, that to know about this all policy and all that, you have to look at the manual. There is a manual of practice and procedure of that patent office. So if you look at that manual, so definitely you can find, or you can identify the change which has taken place in gradually, or by passage of the time and all that. This issue of human embryos, this issue of animal embryos. So for the purposes of public order, morality, and that's why this got prohibited from patentability. And this restriction somehow was removed by a subsequent draft, because when we realized that no, for medicinal use and all that, we can use it, and these are very very important. So we actually changed our policy, and the very approach with regard to this stem cell, particularly this treating stem cells, and the researches which are going in this area. So this issue of public order and morality, and appears to be in contrast to the public policy in India. And we came out with a very important policy, and that is a national guidelines for stem cell research. Uh, National guidelines, and that was published by that Ministry of Science and Technology. So in that Ministry of Science and Technology, they came out with this national guidelines with regard to use of all stem cells and all that. So And what is important here, I have already told you that whenever this issue of this patentability, because it's all about technology, I have already told you that research and development are taking place in pharma industry particularly, and a lot of research and development taking place in pharma industry. And this stem cell is also a kind of technology, but it's not a new concept, but these stem cells are auto-generative cells, and they have the capability of uh, indefinite division, and they can easily be maintained in the laboratories as cell lines. And that's why I can tell you that whenever you might have experienced, whenever a baby gets birth in the hospital, immediately after birth of that baby, many representatives might have approached you, might have approached your relative, that the very parent of that kid, that do you want to preserve the stem cell? Do you want to preserve the stem cell of that newly born baby? So that would, because stem cell bank, so many activities are taking place, so many advancement we have seen in this area. So because so many serious critical diseases can be cured with the help of that stem cell, that can be cured with the help of stem cell. So any kind of repair, any kind of replacement of human tissues, and this treatment, the very treatment, and the probable cure for many diseases, whether conventional diseases, whether non-conventional diseases, the critical diseases, the chronic diseases. So they are very, very helpful. That's why in recent past, they have acquired much popularity, much importance. So that's why so many research is being done in that area. So many inventions are taking place in that area. So are we going to grant patent? That was the question. That's the question. And here I've already told you they are of two kinds, that embryonic stem cells and adult stem cells. There are two kinds. And as far as this embryonic stem cells are concerned, so they can be obtained from uh, certain stages of the human embryo. And where embryo is a gestational, because I give you example of taking up birth of a child, and that, so gestational stage in the human birth cycle. So that's why that's the right time to preserve it. So the moment a child gets birth, and that's the right time to preserve that stem cell, because it is created during that gestational period. So that's our point. Other activities are not our point. Our point is patentability, and for that patentability I have already highlighted the requirements. Even I gave you all the examples of section 3 that tells you that what are non-patentable inventions, what invention cannot be patented. So the approach was very uh, orthodox with regard to this stem cell technology and all that. So whether that was actually a matter of debate, that whether it should be considered non-ethical, or it should be now. Even today, many people, they think it unethical. They don't want to have this preservance of this stem cells and all that, against the moral values. And but at the same time, you can see that a lot of benefits are there, and various benefits it offers. um, I have already given you the examples of बहुत सारे examples मैंने आपको दिए, जैसे बहुत सारे diseases को cure करने में, और that's why ये बहुत ही debatable issue रहा है. और as far as our country's concern is concerned, India uh, and many other countries, they are concerned, and they are actually in favor of the technology in this area. They are in favor of the research and development in the area, but only in case ethical ways are used. only in a way ethical ways are used, and definitely when it is produced by using a particular kind of technology and all that. So even how you make it, so that's also very important. Just making it is not important. How you make it. So some people they adopt a legal way, some people adopt a illegal way. So how it is made. So that's very important. So just making of a thing is not important. Are you getting my point? किसी स्थान पे पहुंचना है तो पहुंचना ठीक है, सिर्फ पहुंचना ही इंपॉर्टेंट नहीं है, आप कैसे पहुंचते हैं वहां पे ये इंपॉर्टेंट है। कुछ लोग सही रास्ते से पहुंचते हैं, कुछ लोग गलत रास्ते से पहुंचते हैं। तो जो गलत रास्ते से पहुंचते हैं उनको रोकना होगा। दे शुड बी प्रिवेंटेड, दे शुड बी स्टॉप्ड। दैट्स व्हाई व्हेन इट इज प्रोड्यूस्ड बाय इन विट्रो फर्टिलाइजेशन, नो प्रॉब्लम। ओके, this aborted fetuses and asexually produced human embryos for deriving such cells, they're not against public order, they are not against morality in any way. Are you getting my point? So when you use all such technologies, or when you take in all circumstances, then somehow it appears that it's not against the public order. It appears that it's not against the morality in any way. But as far as our India is concerned, what kind of policy we have? So in India, the government definitely is supporting nowadays the researchers in this area, and that is you all know that how useful it is, because you need to ascertain the usefulness, utility. I told you, even sometimes on the basis of economic significance, we grant the patent if it is economically significant, if that inventive step is economically significant compared to existing knowledge and art. So definitely we have to look at the broader interest, the larger interest, and considering that larger interest, you all know that in treatment of many diseases, how useful these stem cells are, and that's why we need more and more researches. We need more and more new inventions in this area, this stem cell technology. So that's why, as far as our policy is concerned, India's policy is concerned, so we are actually promoting it. We are promoting it, but we have this 1970 Act. So as far as our 1970 Act is concerned, because whatever we are to analyze, whatever we are to conclude, we are to conclude on the basis of our existing system. So as far as our existing law is concerned, that is Patents Act, and I have already told what requirements are there for patentability and what cannot be patented. I have already explained. So when you look at these aspects, so definitely there is nothing mentioned in our Patents Act which makes stem cells and any research related to stem cells non-patentable. It does not make it non-patentable. We don't find any mention in it, and that's why, as far as the stem cell technology in our country is concerned, so definitely is patentable. And nowadays we are seeing that a good number of patent applications are actually filed every year. Good number of patent applications are filed every year, and many patents have already been granted. Many patents have already been granted. But the previous approach was what? The previous approach was that that was a conservative approach we had, that it is unethical, it is against the public morality and all that. It should not take place, and this is not good considering the morality that should prevail in the society and all that. So we changed that view by passage of the time, when we realized that how important, how useful these inventions are, how useful, how better, how important these inventions are. Because so I told you that repair of the damaged tissues, the repair of the damaged tissues that can be done with the help of, so you all know, in cases of severe accidents and all that, in cases of loss of any organ and all that, failure of any organ and all that, any kind of injury or any kind of disease, these stem cells are very, very useful, and we have proved by various inventions. We have developed so many new technologies in this area, and we are using it in our medical field and medical science, and that's why they are very, very important. So that's why we found this change, and people, they came out with a view that what's the problem of this unethical issue and this public morality and all that. If you were to look at the provision, what provision we have to deal with the patent, what patent system we have, so that is provided by your 1970 act. So if you look at that 1970 act, so definitely you can come to this conclusion that no, there is nothing mentioned in that 1970 act, and that to prevent this stem cell or any related research definitely is not bad to be patented. So there is nothing mentioned to make it non-patentable, and that's why we started recognizing or allowing this stem cell technology in our country, and we have allowed a good number of patents in this area. So we have allowed good number of patents in this area, but definitely. Future will be particularly in this medical science, and the future will be of this stem cell, and we are hopeful that more and more researches will take place, and more technologies will be evolved or will be invented in this area to serve the purpose and to fulfill the requirements of people, particularly in the field of medical science. If anyone has any doubt, I'm ready to clarify. Actually, I have to go somewhere, so that's why I'm concluding my lecture. It's very urgent, so I'm concluding this lecture. I hope I have made you understand this particular issue of patentability, and particularly the patentability of stem cells. With this note, I'm concluding this lecture. If you have any question, I'm ready to answer. Otherwise, we can conclude this session. Thank you very much.
तो सर कोई क्वेश्चन नहीं है.
ठीक है अविनाश. So Avinash Mishra, Avnish Mishra.
अवनीश मिश्रा जी सर.
Okay.
पूरा लेक्चर सर अच्छे से समझ में आया.
तो कैसा रहा?
तो
चार टॉपिक हम लोगों ने डिस्कस किया. चारों टॉपिक आप लोगों को कैसा लगा? आपका फीडबैक बहुत इंपॉर्टेंट है मेरे लिए.
काफी अच्छा रहा सर. अच्छे से जो चीजें हैं आपने एक्सप्लेन की विद द एग्जांपल्स, और उन चीजों को और भी हम लोग
कुछ इंटरेस्ट आप लोग कुछ इंटरेस्ट फाइंड आउट किए लेक्चर्स में?
काफी सारे इंटरेस्टिंग लेक्चर है.
यस सर लेक्चर्स वो वेरी
Okay.
सर बहुत अच्छा लगा, और यू हैव एक्सप्लेन्ड इन वेरी इजी एंड अंडरस्टैंडिंग लैंग्वेज, और हम सभी बहुत बेनिफिटेड हुए सर. थैंक यू.
चलिए, थैंक यू वेरी मच. सो
सर अच्छा भी लगा, और आपसे पहली बार हम लोग इंटरैक्ट भी हुए, तो सर बहुत अच्छा लगा. इन फ्यूचर भी हम लोग को जरूरत होगी तो हम लोग बिल्कुल सर चाहेंगे कि आप कनेक्ट रहें हम लोग.
बिल्कुल, मुझे भी बहुत अच्छा लगा. तो चलिए इसको कंक्लूड करते हैं फिर. थैंक यू वेरी मच. ठीक है.
थैंक यू
सर.
ओके.